Don, let me throw this to you because I think there was a fairly significant, well, it's a Pennsylvania, New Jersey case that we're covered on both ends here on the set here tonight, where someone goes out and gets another job, but they are voluntarily underemployed. In other words, they're out making $100,000, and now they get fired or they leave their job, and they figure, hey, you know what? The ex is helping here. He's going to pay a larger share of taking care of the kids. I'm going to work at a $50,000 a year job instead of killing myself and working 80 hours a week at a big law firm in New Jersey. I'm going to become a paralegal and just work half the time. But what happens then?
Well, I think the general rule is that your income is your income capacity and not your actual income, meaning that if you have a capacity to earn $100,000 a year and then you take a job at $50,000 a year, the argument is that you should be assessed support at $100,000 a year. Now, this Gregoric case in Pennsylvania, actually, my office handled that case, and I sort of thought that turned it on its head because it came out differently than I would have expected. There was a circumstance where the mom was the executive director of the Boy Scouts at around $100,000, and then she took a job as a teacher at $50,000. And the court said that, well, that was a mitigation of circumstances, and we're going to permit it, and we're going to permit her to pay on $50,000. Huh. It was different than I've typically seen those cases. I mean, the arguments you typically make, I would have thought it would have gone the other way, but it didn't. Mm-hmm.